Good morning, everyone. My name is Nikita. Today I'll be presenting on the topic fast track merger. So, coming up with this topic, fast track mergers, Ministry of Corporate Affairs was of the opinion that in order to curb and also to have a better justified procedure so as to merge the companies. So this was a concept which was introduced by the Ministry of Corporate Affairs in the year 2016 on 7th of December. But later on, not exactly later on, after 7 days of issuing the notification, Ministry also notified the rules, that is compromise arrangement and amalgamation rules, on 14th of December 2016. So coming up with the fast track merger, the name itself suggests that there will be a merger, but it will be through the fast route. So this type of merger is also known as a short merger, because the time period involved is much shorter than the merger which is specified under the provisions of 230 to 232. That is the lengthy procedure. So fast track merger can be undertaken between, there is a certain criteria which has been specified by the ministry under section 233 of the Companies Act 2013. So the section particularly states that this type of merger can be undertaken between two or more small companies, and I'll be coming on to the definition of the small company later on. Two or more startup companies, or if we have one or more startup company or one or more small company. So startup company, small company, these two type of companies we are having, we will be having coming up with these two companies will be coming under the definition of fast track merger. And also coming on to the holding company and a wholly owned subsidiary company. So what is a small company? Small company is a company other than the public company, which means it can be only a private company where the paid up capital of the company does not exceed 2 crore rupees, and the turnover of the company in the preceding financial year does not exceed 20 crores. So we have the definition of the small company. Then what is a startup company? Startup company is also a private limited company, but that company has to have obtained a recognition from the Department of Promotion, Industry and Commerce, that is DIP. So coming on to the small, now you have a brief idea about what is a small company and what is a startup company. Now, what is a holding company and what is a wholly owned subsidiary company? So let's take an example. We have A company as a holding company and B company as a wholly owned subsidiary. So if A company is holding around almost 100% in the B company, that is A has invested around 100% in the B company. So then the A will be identified as a holding company and B will be identified as a wholly owned subsidiary company. So now, considering means now I guess people are clear about what type of companies can go through the fast track merger. So coming on to the brief about what all steps are involved, I'll just let you know what the timeline and the forms which are involved. So coming on to the section which I've already told you. So section 233 of the Companies Act deals with this fast track merger. Then we have Rule 25 of the Companies Compromise Arrangement and Amalgamation Rules 2014. So like from the rule only we can identify that it says compromise arrangement and amalgamation. So whenever the form will be involved, whatever forms will be involved through this process, the form will start with CAA, that is compromise arrangement and amalgamation. Then there was certain notification, like I told you that the Ministry of Corporate Affairs came up with a notification in 7th of December 2016. So that's the notification number which is stated. And then again there was when this section was notified, earlier it was power was given to the central government. But then again it was notified that the power given to the central government has been delegated to the regional director. So this notification which I stated that was issued on 19 December 2016. Then there are certain other sections which are also involved, because if one company is merged into another, then basically that company there are certain acts which are applicable to the company, like Income Tax Act, like other specific acts. So whenever this type of companies, whenever a type of companies merge into another, then the income tax and the stamp duty provision. So we have to take wholesome attitude towards approach means wholesome approach towards while considering the fast track. So now I've already discussed the applicability. Yeah. So what was the basic concept of introducing the fast track merger? So as I informed you earlier, that this was basically introduced so as because see under the Modi government, the Modi always says that there's a ease of doing business, ease of doing business. So that's a basic step which was taken up by the Modi government, and then basic concept of introducing this concept was to facilitate the ease of doing business. Then means whenever we go to the court, there's a lengthy process which is involved. Like multiple times there's a hearing schedule, and then there's a time and cost involved. Because obviously we'll be hiring a professional because nobody has so much of time that the every time a hearing is scheduled and we have to go to the court for attending of the hearing. So as to curb that, this concept was introduced. Then already informed, so I'll elaborate further that RD though take this decision whether to approve this merger or not, but that basically depends upon the regional registrar of companies and the official liquidator, because even RD has a lot of work because RD has to depend upon someone so that concerned department issues their report and RD relies on them and then basically approves the scheme. So I'll discuss that later on. So yeah, so coming on to the forms which are used. So first I'll start with the process, and so accordingly I'll in the mid I'll elaborate about the forms. So as informed that section 233 of the Companies Act 2013 is deals with the fast track merger. So like for any if we are handling a company, so like for any company, the board of directors are the responsible persons. So the board of directors, before like I am considered, because merger is such a major step. So if the board of directors are considering, so both the transferor company and the transfer company, the board of directors of both the company will be considering this scheme. So first they'll consider what all means benefits they'll arrive after merging the transferor company to the transferee company. So the board of directors will definitely convene a meeting for that, and in that meeting there are certain things which are to be taken up by the board of directors. So first of all, the board of directors will consider the scheme of amalgamation. So after considering the scheme of amalgamation, the power of the board of directors is not absolute under this section. So that board of directors depends upon the shareholders and the creditors of the company. So they will fix the day, time, and meeting of the shareholders. Then we have to obtain a valuation report from the registered valuer regarding the fair valuation of the the shares of the company, because the company the transferor company has paid up capital and the shares. So that transferor company, we have the register valuer will give us the exchange ratio at which the shares will be issued to the transferee company. Then we have the board meeting. There means we took note of the scheme of amalgamation. Then we took note of the notice of the shareholders. Then the creditors, we have to convene a meeting of the creditors if we have the creditors in the company. So then after coming on to when the certain points are discussed in the meeting, so what is that means the board of directors will basically issue the notice of this scheme of amalgamation to the regional director and the official liquidator. So after issuing that notice of the scheme of amalgamation, the form used for the notice is C9, like compromise arrangement and amalgamation C9. This form will be used. This is not an e-form. This is basically a format which has been prescribed by the authority. So that C9 will form in C9. We will basically file the give the notice of the scheme of amalgamation, scheme of merger to the registrar of companies or official liquidator in where the registered office of the company is situated. So here, whatever steps I am defining, these steps are applicable to both transferor company and transferee company. So both companies have to take care of it. Then after issuing this CAA 9, the company will wait for, means there's a time period prescribed, the company has to wait for 30 days in order, if the if the ROC or the official liquidator has any objections with respect to the notice of the scheme of merger, then we have to wait for at least 30 days. Then before convening the meeting of the shareholders, we have to file a declaration of solvency with the registrar of companies. So there is a form prescribed by the registrar of companies. We have to intimate. So there is a general form, that GNL1. So we'll be intimating to the ROC regarding the declaration of solvency. So basically, like the declaration of solvency, the name itself suggests that we will be basically attaching the financial statements of the company, the book value of the assets and liabilities, the copy of the board resolution. So there's a certain things which will be described in the declaration of solvency. And yes, the meeting of the date and time of the meeting of the board of directors and of the members. Then after issuing of the notice of the amalgamation, notice of the merger in CAA 9, I told you about the declaration of solvency. So the form prescribed for declaration of solvency is CAA 10. So now we are covered up with CAA 9 and CAA 10. Then coming up to CAA 11. So basically now declaration of solvency has been filed with the registrar of companies. Now, board of directors, I told you that the power of the board of directors is not absolute, so they want the approval of the shareholders. So now the shareholders meeting is convened. So after the meeting is convened, so we have to ensure that whatever the objections, if any, raised by the ROC or the official liquidator, has been incorporated in the scheme of merger before presenting it to the shareholders, because ultimately they are the ultimate holders of the company and they will be providing the approval for the merger. So we have to ensure that the objections, if any, raised, has to be incorporated in the scheme of merger. So when the scheme of merger will be presented to the shareholders, so there are certain points, mandatory points which are to be covered. I'll not elaborate enough, but I'll do let you know what are the basic points which are to be covered in the scheme of merger. So like scheme of merger, we have that what is the basic benefit of going into the fast track merger? We have to elaborate it in the scheme. Then we convene the board meeting, the date and time of the board meeting. Who will be the registered valuer of the company? Then we have to, I missed that. We also require an auditor's certificate confirming that the accounting treatment as prescribed under section 133 of the Act has been complied with. So all these details with respect to that has to be incorporated in the scheme of merger. Then also the shareholders meeting, the date and time of the shareholders meeting, and then coming after convening the shareholders meeting, we will convene the creditors meeting. So in that creditors meeting also, we have to ensure that we have obtained the approval of 910. That is basically 90% of the share, 90% of the total creditors of the company. And same goes for the shareholders also. So 90% is both for the shareholders as well as for the creditors. So after obtaining the shareholders and the creditors' consent, we will file the final scheme of merger, which has been approved by the shareholders and creditors to the regional director. So the form prescribed is CAA 11 for that. So, and also one thing to note that it is not necessary to hold a creditors meeting. If I ask my creditors that please provide me with the consent, and if they provide me in the written form, we can dispense off with the requirement of meeting, convening a meeting of the creditors. So after a scheme has been filed with the regional director, so then regional director, and yes, after issuing the scheme of merger to the regional director, we also have to file the same with the RD and the official liquidator. Earlier the notice was filed, now the final scheme has been filed. So now again, RD will provide the time to the registrar of companies and the official liquidator. So as to, if they have any objection to the final scheme of merger, they can provide the same within 30 days from the date of filing of the form CAA 11 with the regional director. So after considering that 30 days, the regional director has been given the absolute power. We would say that the regional director has the power, either it can reject the scheme, or it can approve the scheme, or it can recommend the scheme to the tribunal. So what all tribunal here refers to the NCLT, that's National Company Law Tribunal. So the power of giving such authority to the regional director to recommend the scheme of merger to the tribunal is if it goes against the public interest. It is not in the public interest so as to merge the companies, or if any normal means general public files any objection to the regional director that they oppose the scheme. So regional director has a power that it can recommend the tribunal to consider the scheme. Then that scheme will not covered under the section 233. That's the fast track merger is not there. Now we have to go through the proper merger route, that is 230 to 232 of the Companies Act 2013. So after the approval of the scheme, and yes, when the order is approved by the regional director, the means the format prescribed is CAA 12. So that's the basic order form which will be issued by the regional director. So post issuance of the order means I am considering that my scheme is approved by the regional director. So after considering of the scheme, we have to intimate to the ROC that our scheme has been approved by the regional director. So there's a form prescribed under the Companies Act, that's INC 28. So that has to be filed in 30 days from the date of receipt of the order from the regional director. So after that, when the INC 28 has been filed and the same has been approved by the authority, we will simultaneously consider, because see, now the fast track merger process is completed on my part. But what happens to the that transferor company? I am the transferee company, and transferor company, the what happens to its paid up share capital, the price capital. So that things also have to be undertaken. So also the effect of merger under this, I would say that all the assets, properties, liabilities of the transferor company will be the assets, liabilities, and properties of the transferor company. Sorry, transferee company. Then coming on to if there was any legal proceeding which was going on against the transfer company, that will also be going, because the effect of the fast track merger is that without going into winding up, the company is dissolved. So if the company doesn't exist, so that all the liabilities, assets, whatever the transfer company was having, now it will be part of the transferee company. So now we have that means property, assets, and liabilities. Then also the legal proceedings, and also if there was any share exchange, like there was some dissenting shareholders. So that we also have to take note that the proper means the dissenting shareholders are given proper chance to be a part of the transferee company, and if not, then proper exit route will be provided by the transferee company. But the same is not applicable in the case of holding and wholly owned subsidiary, because holding company is the only shareholder, and if the shareholder gave the consent at the time of shareholders meeting, now why would he dissent the same? Because that will basically contradict its own decision. So after that, considering the effect of the scheme, now coming up to the authorized share capital. Now my company's authorized, the transferee company's authorized share capital is 1 crore, and the transferor's authorized capital is 1 lakh. So now what the company is dissolved, so 1 lakh authorized capital will be merged into the authorized share capital of the transferee company. So now after post merger, the authorized share capital of the company will stand at 1 crore 1 lakh. And also, if there were any charges which were existing at the time of merger, so now the same will be enforced against the transferee company, because the transferor companies law basically lost its existence. So now, if I am a general public, I have to enforce anything. If there was a case pending, then I will basically definitely go against the transferee company, as the transfer company was merged. Then, so for making this, to get the charge enforced, to amend the authorized share capital of the company, we have to file a separate application to the ROC post final approval of the scheme of merger. So after that, means there's a prescribed form, that's GML1. We have to file an application to the registrar of companies for approval of so as to amend our authorized share capital, and also means if there is any charges, so as to update the index of charges as well. So post that, and then there are stamp duty provisions as well, because see, 1 crore on the share capital of 1 crore, the transferring company already paid its stamp duty. on the authorized share capital of the transfer company of rupees 1 lakh, the transfer company has already paid stamp duty of rupees 1 lakh. Now, when the revised authorized share capital of the transfer company is 1 crore 1 lakh, so why would means the transfer company would be paying additional stamp duty on rupees 1 lakh? So there is no requirement of such additional stamp duty requirements. So we just have to intimate to the ROC, and ROC will intimate, approve the same, and means the portal, the master data of the company will be reflected with the amended authorized share capital and the amended charges of index of charges. So means this is basically the crux of the fast track merger, and means this was basically introduced so as to means save our time and other. So your questions are welcome if you have any.